Good morning, everyone. My name is Cindy Tania, and my teammates' name are Rifada, Rakha, Keisha, and Najwa. Now, we're going to discuss about Industrial Relation Court's decision number 56 of Pedetesos PHI 2024 PN Semarang. Next. Now, just a bit background of the case. So there is two plaintiffs, Sudirno, working since 1980, and Mulyono since 1985, which had been doing some. Guys, ilang maaf. So sorry. Di ka pa naman kita. Jangan lupa. Alright. Had been serving as KDs at Semarang Royal Golf Course for throughout this period, they have worked full time under fixed schedules determined by the management, were supervised by caddy master and HRD, received a monthly KD fee, which function as wages, were and also were subject to sanction if absent, showing employer control. Now, even though the golf course management changed multiple times, the working continuously, and eventually the management was taken over by PT Semarang Pesona Semesta, which is the tergugat satu, PT Ardina Prima, tergugat dua, the mayor of Semarang, which is also being a tergugat, which is called as Toro Tergugat, as the landowner of the golf course. Now, the triggering event was in May 2023, where the new management was forced with and Mulyono to sign kamitraan or a partnership agreement, which would reclassify them from being employees to partners. The plaintiff refused because the kamitraan status would remove their legal rights as workers, including the job security and also severance. Now, the consequence for the plaintiffs is because they refuse it. There are four. They were barred from entering and working starting the 1st June of 2023. Second, they received no severance, no compensation, and no legal entitlements. Third, attempts at bipartite negotiation were also being rejected. And lastly, is multiple mediation sessions as this knocker were held but ended up in deadlock. Next. Now, furthermore, the type of dispute of in this case is the case falls under industrial relations dispute, and it involves two specific categories. First is PHK dispute, because this arises because Sudirno and Mulyono were suddenly barred from working and after refusing the Comitran agreement. From their perspective, this amounted to unlawful termination since no proper PHK procedure was followed, and there were no given severance or compensation. Second, a rights dispute regarding employment status and entitlements. The plaintiffs argue that based on the decades of the continuous work, supervision, schedules, BPJS, and the monthly wages, they were actually employees or pekerja tetap, not partners. Because of that, they claim they are entitled to pesangon, penghargaan masa kerja, and other statutory rights under the labor law. So overall, the dispute consists of a dispute and a rights dispute, both examined within the industrial relations framework. Next. Now, there are several industrial relation procedures that were attempted before this case has been reached to the PHI. First is bipartite negotiation. After being barred from working on the 1st of June of 2023, Sudino and Mulyono requested a bipartite meeting with the management Tergugat 1 and 2. However, the management refused to hold the meeting, so the bipartite process has failed. Now, second, the mediation at the Disnaker Kota. Because bipartite failed, the plaintiff filed a formal complaint to Disnaker Kota Semarang. There were 4 mediation sessions, but no agreement was reached regarding the amount of compensation. So the mediator then declared the mediation to be deadlocked. Now, third, attempt to obtain anjuran tertulis. Now, legally, after a deadlock, the mediator must issue an anjuran tertulis. But in this case, the mediator did not issue it. The plaintiffs even sent 2 reminders letters, but the mediator responded that the matter was not fully their authority. Fourth, escalation to Disnacar Province. Because the city office refused to issue an anjuran tertulis, the plaintiffs escalated their complaint to Disnacar Province, Jawa Tengah, which then instructed the city office to continue mediation. Another mediation was held, but still no settlement was reached. Fifth, there is issuance of mediation record or risala. Eventually, Disnacar Kota has been issuing Risalah Medias, stating that the matter was not fully within their jurisdiction and the parties were free to bring the dispute to the court. Now, finally, the case was filed at the PHI. Because bipartite and mediation processes has failed, the plaintiffs proceeded to file to their lawsuit at the Pengadilan Hubungan Industrial PHI PN Semarang. Next.
In this case, the central legal question is whether the two caddies should be treated as a permanent employees or pekawetete, rather than partners as the company tried to classify them. These caddies had been working at the golf course for an incredibly long time, one for 38 years and the other for 43 years. Their work was not casual or flexible. They followed a fixed schedule set by the management. They had to clock in and out. They were supervised by the HRD and the caddy master, and they received monthly payments based on their duties. The company even enrolled them in BPJS. So all these elements clearly show that the relationship was that the employer and employee. However, when the new management took over, they asked all caddies to fill out the partnership application form. So after the two men submitted the form, the company rejected their application and immediately barred them from entering the workplace. By calling this a partnership rejection rather than a termination, the company attempted to avoid paying severance and long service compensation. So the issue before the court was, based on the actual facts, could these caddies be legally recognized as pekawetete? If yes, then the company's actions amount to an unlawful dismissal, and they're entitled to a full severance, long service pay, compensation for unused leave, and other rights guaranteed under the Indonesian labor law. So in short, the dispute is about whether the company can hide behind the label of partnership, or whether the law should look at the real working condition, which clearly point to a permanent employment relationship.
Moving on to the next slide in regards to the legal consideration towards the case. So first of all, we need to consider the existence of an employment relationship. So as have been mentioned by my teammates beforehand, there are evident relationship between the plaintiff and the defendants, and it also has fulfilled the three essential elements of employment. First, wages, where there is monthly caddy fees being paid towards the caddies. And second, work. Plaintiff carried out daily duties at the golf course, being a caddy. And then thirdly, lastly, there is an authority or a subordinate and superior relationship between the caddies and also the one who is in the management. Moving on to the second consideration would be the responsibility of the new management. Under Article 61, paragraph 3 of Job Creation Law, it covers the cases of transfer of management and which the workers' rights remain protected and become the responsibility for the new employer. In the previous management, they are employees, and considering the changes of management, they should also be considered as employees if there is, severance pay and all. And continuing to the severance pay that I have mentioned early on, it should also become one of the considerations. So severance pay must be granted as established under Article 156, paragraph 1 till 4, that the P are entitled to first, severance pay, second, long service pay, and third, compensation for entitlements. So it doesn't make sense if the management will sever both of the caddies without any kinds of payments, considering that they are not employees from their point of view. Now, lastly, for the consideration would be pekawetete as the classification. The plaintiffs had continuously work for many years without interruption within the last management. Under the Job Creation Law, repeated extensions result in automatic conversion into pekawetete or permanent employees. So again, they are and they should receive those payments as an employee.
So next is the decision of the decision. And the court ruled that this lawsuit is tidak dapat diterima or NO. And what does it mean? So the case was rejected due to procedural grounds because there are some required legal steps that was missed by the plaintiffs. Thus, the court refused to assess the case, but the plaintiffs could retry the claim after fixing the incomplete steps, which is the mediation. And why was the lawsuit rejected? The judge found out that the plaintiffs did not comply with Pasal 83 Ayat 1 UU Number 2 Tahun 2004 tentang penyelesaian perselisihan hubungan industrial, which requires mediation or conciliation between the plaintiffs and the defendant. So next is the judge's notes and conclusion regarding this case is gugatan hanya dilampiri dengan risalah mediasi antara para penggugat dengan PT Ardina Prima or tergugat 2, sedangkan gugatan juga mencantumkan tergugat 1 dan turut tergugat, meaning that the plaintiffs included multiple defendants, yet they did not do mediation to all of the defendants before filing for lawsuits. And the full amar putusan for this case is excepsi or preliminary objection from defendant 1 is accepted. The claim is declared as NO, and the court fees are charged to the state as the disputed amount is less than rupiah 150 million rupiah. However, the effect of this procedural decision is the court did not proceed to examine whether there was an employment relationship between the defendant and the plaintiff. Next, they could not decide whether the termination was illegal. Third, the order, severance, or benefits. There are no order severance. And lastly, they did not evaluate evidence or testimony from the plaintiffs or defendants.
And on to the next one, we have the opinion and analysis. So the Industrial Relation Court in Samarang made the correct decision in recognizing the plaintiffs as workers, not the partners. For years, they worked under full employer control. The company's partnership label was simply a way to avoid obligation like severance and job security. The court rightly focused on the reality of the working relationship, not the title imposed by the employer. And this ruling sends an important message, which is the first one is permanent roles deserve permanent protection. Long-serving workers cannot be dismissed without responsibility, and employer accountability continues even when management changes. It also supports the human dignity in the workplace in line with the ILO standards and the ICESCR and Indonesian Constitution. Our position in here is that we fully support the court's decision. At the same time, this case exposed a wider problem. Millions of workers in informal or semi-formal arrangement are still vulnerable to exploitation through unfair contracts, and we feel that to prevent similar abuses, reforms and stronger oversight are needed so that employers cannot be downgraded employment status after the fact. Workers performing core business roles receive full protections, and local governments will prevent labor exploitation on public assets. Therefore, we feel that this case is a positive step, but it also shows how much work remains to secure fair treatment for all workers. And that's all from us. And we hope that hopefully everyone can gain a lot of information on the presentation that we have discussed regarding the industrial case. Therefore, and thank you so much for your attention and have a good one.
You.